Surprise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good morning and welcome everyone. Madam Court Officer, could you please call the case?
Good morning, Your Honors. This is case KAC BC 2020-05, the Specialist Prosecutor versus Salih Mustafa.
Thank you, Madam Court Officer. I will now call appearances. Mr. Prosecutor, could you tell us who is present for the Specialist Prosecutor's Office, please?
Good morning, Your Honors. Good morning, everyone. The prosecution is represented today by Silvia D'Ascoli, Associate Prosecutor, Filippo De Minicis, another Associate Prosecutor, Julie Mann, our Case Manager, Agathe Tregaro, the SPO Intern, and my name is Cezary Michalczuk. I'm the SPO Prosecutor.
Thank you. Victims' Counsel, you have the floor.
Good morning, Your Honours. Good morning, everybody. The participating victims in this case are today represented by Lisbeth Zechfeld, co-counsel, and by myself, Annie Poes, as counsel.
Thank you very much. Defense Counsel, you have the floor.
Good morning, Your Honor. The defense is represented by myself, Julius van Manet, Fatim Shala, my co-counsel, interpreter and investigator, Mr. Fatmir Pillai, and joining us via remote is Mr. Mustafa. Thank you very much.
Thank you very much. The registry, you have the floor.
Good morning, Your Honors. Jonas Nilsson, Judicial Services Division, Registry.
Thank you. Mr. Mustafa, does the connection work okay? Can you hear us fine?
Yes, Your Honor.
And for the record, you're appearing in front of trial panel 1. Today we will hold the Defense Preparation Conference and the Victim Status Conference, which precedes the presentation of evidence called by the panel upon Victims' Counsel request and the opening of the defense case. And before we start, and for the benefit of the public, I will give a short procedural history. The SPO opened its case on the 15th of September 2021 and presented evidence between the 20th of September 2021 and the 2nd of February. And the SPO formally closed its case on the 4th of February 2022. That's filing 308. And on the same day, the defense notified the panel that it intended to file a motion to dismiss any or all of the charges against the accused, and that, should the motion be rejected, it intended to present the case. That's filing 312 and 320. On the 23rd of February 2022, the panel rejected the defense motion to dismiss the charges, filing 326. And on the 1st of March, upon instruction of the panel, the defense and the Victims' Counsel filed their submissions regarding the oral and non-oral evidence that they wish to present in front of the panel, filing 333 and 334, respectively. On the 7th of March, yesterday, the panel received submissions from the defense, filing 335, the registry 337, and the SPO, filing 338, on the defense case and the presentation of evidence called by the panel upon Victims' Counsel's request. The purpose of this conference of today is to prepare for the presentation of the evidence called by the panel upon Victims' Counsel request and for the defense case. The intention is to go through the agenda set out in the second decision of the conduct of proceedings, filing 296, and address some other issues from the defense, the SPO, and Victims' Counsel submissions. After that, the parties and Victims' Counsel will be given the possibility to raise any other issues they deem necessary. And the panel will then render tomorrow, Wednesday, a number of oral orders at 2:30 in the afternoon. And before we start with the first item, I kindly ask the parties and participants to adhere to the agenda set out in our decision and of course, as far as possible, not to repeat what we have already been able to read in your written submissions. Okay, first item on the agenda. That is the opening statement by the defense. Yeah. The defense has indicated, defense counsel, it will be making an opening statement. It's filing 333. Would the defense be ready to make its opening statement on Tuesday, 22nd of March? And then another point I want to make, the panel further notes the defense submissions, filing 333 and 335, indicating that it will need 2 hours for its opening statement and that visual aids and other tools will be used. And the panel wishes to remind Defense Counsel that it will need to communicate to CMU, the SPO, Victims Counsel and the panel, the visual aids, so the maps and the photographs, that it intends to use by reference to the ERN number under which such visual aids can be found in legal workflow. And should the defense intend to disclose any visual aids which not have been previously disclosed, then it should be made available to CMU, the SPO, the Victims Counsel and panel in electronic form, and they should be added to legal workflow before the opening of the defense case. Defense Counsel, you have the floor.
Microphone. I'm trying to find the calendar. The 22nd of March is a Tuesday. Okay.
Next week the court is not at our disposal, but the week after it is. So we would like to continue.
I understand. I had estimated the first witness in the first week of March, and therefore we were in the
Defense Counsel, you
Yes.
said March. I assume you
April. Sorry,
April.
first. And therefore it would be helpful if it would be in the last week of March that we can do the opening statement. It goes in the sequence. And actually, we were wondering whether it was possible to make an opening statement and follow up with the first defense witness on that. I estimated about 2 hours. I think it's a rather long estimate. In any event, we think it would be done within, let's say, we start at 9:30, at 11 o'clock. That is how I estimated it, that it would be within that time frame done. And then afterwards, we could actually start with the first defense witness. That was a little bit the idea that I had. If you would like to do that earlier, that would be possible. I think we would like to consult with our client regarding it, but we would prefer 1 week later start. At least we want to have it a little bit connected to the first witness of defense, just not to lose any time in that perspective. So that was just the idea that we had.
Yeah.
But
On the issue of time, that's exactly one of the factors we take
Yeah.
into consideration,
Yeah.
and that therefore it would be helpful to, if we are ready to start as soon as we can.
yes.
And we will discuss further on also the start, the possible start of the
Witnesses.
interrogation of the witnesses, because maybe we could do something with that too, and maybe anticipate that also. But we will discuss that later. But I didn't hear a no, but I heard you say I would like to consult with my client. So I will give you the opportunity to consult with your client. But for planning reasons, purposes, if there are no hard issues not to do it, we would have a preference to start as soon as possible, and that would be, but we are just tentatively now seeing what is possible to start then. But I will give you the possibility during the break, which we will have as usual at 11, to consult with your client.
And as far as the visual aids is concerned, we do not expect to use any visual aid that has not been disclosed in our disclosures. Probably a map, some other things that we have compiled, this kind of things. And that's why we do not always know how that works with visual aids. That's why the estimate was 2 hours. But my intention is to do this within the 1.5 hour that we use usually, as we are doing it now from 9:30 until 11. That's why the estimate is on the rough side, so to speak.
So within one session, I understand that making very precise estimates is not always easy, but it's not necessary, I can tell you, to make too rough estimates, because the panel, if you reason why you think you would need more time, is always open to discuss that. So.
In any event, and that counts for everything, I would like to say that, is that with all our estimates we try to obviously limit the scope of things, of whatever we want to do. So that's why I think even with this, I estimated 2 hours. That's maybe just going over a one session or just staying within it. That is the target that I set for myself.
Very well. Mr. Prosecutor, would you like to raise anything in this regard?
Your Honor, nothing in particular. We first of all welcome the willingness of the defense to deliver the speech within a shorter time frame than he indicated, and to proceed immediately with the first witnesses. As we understand from the submission of the registry, they would be ready with the first witnesses on that week, and the date was indicated in the submission. For the prosecution, Your Honors, the sooner the better.
Thank you.
24th, for example, would be perhaps a good day to start with the first witnesses. Thank you.
Victims' Counsel, would you like to make any observations?
Your Honours, apart from that we are ready to proceed whenever the parties are, no.
Thank you. Very well. I will pass to the next topic, and the issue of when to start will come up at further issues we will discuss during this conference. The next topic is the order of the defense proposed witnesses included in the list of witnesses submitted to the panel on the 1st of March 2022. That's filing 333. Defense Counsel, the panel notes your submission of the 6th of March, filing 335, in which you indicate you wish to follow the order of the witnesses indicated in Annex 1 of filing 333. Yes, I see you nodding. Yes, thank you. And on this point, the panel would like to inquire with the registry whether it would be feasible to organize the testimony of the witnesses in such a way that if a witness finishes her or his testimony earlier than expected, the next scheduled witness can start with her or his testimony immediately afterwards. You have the floor, registry.
Thank you, Your Honor. In short, yes, it is possible to have witnesses lined up within reason. We, of course, plan the witnesses' travel and so on in accordance with the estimates given by the parties, but it is possible to have witnesses lined up so that testimonies can continue in continuance.
Okay.
Thank you.
Thank you. Defense counsel, would you like to make any submissions on this point?
No, actually, we wanted to group some of the witnesses because we thought they would be in line. And to be quite honest, we, for the first witness, calculated in the working conditions of the people involved. That's why we thought that the first week of April would give them at least the time to organize. I consulted with the WIPSO regarding this, and they, well, within those consultations, we said for about 3 weeks things are necessary to organize. But if we can start earlier, that's fine with me, as long as we try to keep the order as it is. We will see, I think, along the way that, as we have seen with maybe prosecution witnesses too, that some people might not be available at some point and go into another slot, so to speak. But you know, we have to go about it as we find it. But I think very few times we will have problems with people appearing, just in the cases that they have particular working conditions, or they're self-employed, or have a practice to take care of. Then that takes organization for them to do that.
Yes, but some kind of flexibility is, of course, requested. Yeah. But I hear you say that you will do your utmost, and the witness to organize that.
Absolutely.
Okay, that's. Thank you for that. Yes, Mr. Prosecutor, would you like to raise anything in this regard?
No, nothing else, Your Honor.
Okay, Victims' Counsel.
No, Your Honors, thank you.
Okay. Now, we noted the submissions made, although this point still will be elaborated some more at a further moment in this conference. The next topic is the request for protective measures for the defense proposed witnesses. Defense Counsel, the panel notes the defense submission that it might request protective measures for one witness. That's filing 335. And the panel would like to know whether the defense will be able to indicate to the panel by Monday, 28th of March, whether such a request will be made and for which witness such request is being considered. And in order to preserve the confidentiality of such information, you can respond by indicating the witness pseudonym or the witness number, as you wish, as indicated in the defense list of witnesses. You have the floor.
At the time of filing, I was not completely sure. I think it is only in one occasion, and for the 28th there is no problem to inform you about that, whether that will be necessary at all.
Thank you. Mr. Prosecutor, would you like to make an observation on this?
Your Honor, no observations.
Thank you. Victims' Counsel, do you have anything to say?
No, thank you.
Does the registry want to make an observation on this point?
No observation. Thank you, Your Honor.
Since the defense has already indicated that it does not intend to request redactions to any other material, I will now move to the next topic, and that is the start date of the presentation of evidence by the defense and the organization of the defense witness testimonies by the registry. Defense Counsel, The panel notes your submission indicating that the defense would be ready to start its presentation of evidence in the first week of April. As you already told us before, that's filing 335. We noted the submission of the registry indicating that the appearances of the first 7 witnesses on the defense list of witnesses for which complete documentation was available, so not the first witness. There I saw that passport copy, something like that, was missing, can be facilitated at the earliest on the 24th of March 2022, and that's filing 337. Yes. The panel would nevertheless like to ask the defense whether it would be in a position to call its first witness on Wednesday, 23rd of March 2022, and then to continue in the week of the 28th of March. Taking into consideration that the panel will be able to use the courtroom on the 23rd of March for a full day and also for a session on Thursday, the 24th. And the panel would have a preference to hear 1 witnesses for which the defense estimates a shorter time for direct examination, such as witness number 11 on the defense list of witnesses, which is witness 1100. And on this point, the panel would like to inquire with the registry whether appearance of witness for the defense 1100 could be organized for Wednesday, 23rd of March, taking into consideration the aforementioned date of the 24th of March as the first day in which an appearance of a defense witness could be facilitated. Defense counsel, you have the floor.
Your Honor, I didn't catch it well. Starting with the first witness on the 23rd of March. That is the question. I'm not sure about the first witness because I think with this witness that might be too short for the witness to make arrangements. But I cannot be conclusive about it. I know that for that witness we have, I believe, yesterday we organized his passport. But to move witness 11 all the way up, I don't think that would be preferable, as this witness is connected to witness 9 and 10. It would not make, I don't think it would not be a good order to move that person all the way up. I think that just simply to connect it to witness 9 and 10, I think that would not be a good choice to do so, even though it is limited in scope. As I say, for the other witness, 9 and 10, I've estimated 5 hours, which I calculate like half a day, or not a complete full day, but half a day. Therefore, I think it would not be wise to do that, Your Honor. The first witness appearing on the 24th of March or either the 23rd of March is, as far as I'm concerned, okay, if it is possible for the witness to do that. I do not have that in mind. We estimated that for that witness, he might have needed to take some more time, and also the second witness to organize properly work or professional obligations in order to be able to testify. That's why. That's why my estimate was the first week of April, then be sure that we have lined up everybody properly.
Yes, but we have 2 weeks now, and I don't want to. We don't
No.
want to lose those 2 weeks, and lose in the sense of having an empty courtroom, whereas everybody is ready to move on. So one way or the other, we really have to make it work.
Yeah.
I would say, and also in the interest of your client, to proceed as fast as we can within, of course, the logistic and organizational and the organization also of your defense case. Let me be clear on that, that we don't want to interfere with that, but we need to organize it. So what if I summarize, I hear you say that witness 1100, you see it as problematic because although limited in scope, he is connected, or the witness is connected to witnesses 9 and 10.
May I interfere for something?
Of course.
Could we just consult among the defense to move another witness up in that particular matter, to see whether we can finish another witness within the date of the 23rd of March. If the issue is to use the 23rd of March for a witness, then we would rather prefer to have to seek another witness rather than that particular witness that you just indicated.
Yes, but that was going within my summary. Was a step up to bring you to my next point. But I see we are on the same line, so that's good. That we have another proposal that would be that would be a witness who already has testified in court, defense witness 1900. That witness has already appeared before the panel in February 2022. We have had the parties and the victims' counsel and the panel have had the possibility to prepare for the examination of said witness. And alternatively, if you could propose any other witness would be ready to testify on the 23rd of March. That is, the order I had in mind. And we had chosen the first one because of the limited amount of hours you have proposed. And we still have to look at the amount of hours that you have estimated, but that's another topic. But yes, please, if you have another witness that could come on the 23rd with the possibility of one session on the 24th, but all that, before we do that, I have to go, while you think, Mr. Defense Counsel, I will go to the registry now in order to see what the possibilities are, because the proposal of the panel implies an anticipation of 1 day from the 24th to the 23rd to have a witness ready for its testimony in court, his or her testimony in court. So, yes, registry, you have the floor with regard to the possibilities to do it on the 23rd, or to start on the 23rd.
Thank you, Your Honor. With regard to number 11 on the list, I did some quick consultation, and it appears that it is possible to do it 1 day earlier than we had indicated for this particular witness, so on the 23rd already, so that's number 11. The first witness on the list, you have already indicated there is a problem with the passport copies, so it's difficult to commit to until that has been resolved. And with regard to the third witness that has been mentioned, which is number 19. There is still outstanding, and we still have to do a visa request. I'm afraid the earliest it can be done for that witness is the week of the 28th of March.
Thank you.
For the 19 on the list, unfortunately, the earliest I have right now from my colleagues is I'm trying to consult very quickly, but it's the week of the 28th of March, unfortunately.
Okay, very well. And with regards to the witnesses, starting with the second witness on the list, in the registry observations, the panel noted that there were 7 witnesses, not consecutively, but 7 witnesses which would be ready to testify, could be ready to testify from the visa point of view on the 24th. Would those witnesses be ready also on the 23rd?
All I know specifically is number 11, but I'll follow up and see right now and see if any of the others could be one day early as well, just like 11.
Because I think that would be of use for defense counsel, isn't it? If you would know if one of those witnesses mentioned in the submissions of the registry filed yesterday, if they would be ready on the 23rd, because then you could assess if one of them could be possible. And if you have somebody else, please propose, because then the registry can inquire what the possibilities are. But it is my understanding that the 7 witnesses on the list of the registry that would be available the 24th are more likely to be also ready on the 23rd. I saw you standing, Defense Counsel. You have the floor.
Yeah, I think honestly to be that within the first 7 witnesses, that would be one of the witnesses that our mind goes to move it forward.
Okay, and I have
to, excuse me, that is the first 8, number 1 until 8.
Yes, but number 1, as we were informed again, there is a passport problem. There is not yet a copy of...
We have that. We as of today, we have that because we have organized that yesterday.
Okay.
So that's for sure.
Very well.
That is done.
The registry, you have the floor.
Thank you. Even if we receive the passport copy today, well, it might not be possible for the first witness until the week of the 28th March. But I did receive just now confirmation that for all of the 7, it is possible to move it one day earlier to the 23rd, if that's what the panel wishes. So for witness number 2, 3, 4, 6, 7, 10, and 11. So all the 7 witnesses that we indicated could be ready on the 24th of March. They can be ready one day earlier, if that's is helpful. Thank you.
Thank you very much for this quick follow-up. Defense Counsel, my request to you for now would be that the bottom line is that we would like to start on the 23rd, and we would like to have a witness for that day. I propose to leave you in the break for a consultation with your colleagues on this matter, and then after the break you can come back to us, and we can discuss it some more, and I hope you can come with an answer on this. But we appreciate very much your willingness to try to organize this matter.
May I ask, Your Honor?
Yes.
So, let's say we would start on the 22nd of March with the what is it, the opening statement, and we would proceed the following day with the first witness. That first witness would be number 2 on the list.
That would depend, of
Yeah.
course, on you.
Yeah, because we have then the 23rd and the 24th.
Only in the morning. We were searching for a witness which is not too long, because if not, that would imply that the witness would not be finished on the 23rd, because in the 24th in the afternoon there is already another hearing. You can see that on the public calendar of the KSC. And Friday, I know that the courtroom is not available. So, as you see,
So we're looking at the 23rd of March only in the morning. That is
24th.
24th in the morning.
Uh,
Let me just
No,
get
but-
back to you on this issue.
Yes, very well. For now, it has been a small debate between the registry and the defense counsel, but I look at Mr. Prosecutor. Would you like to make an observation on this point?
As an observation, we are not going to organize the defense. It's not my intention to indicate anything or my purpose. I mean, if we started on the 23rd with the first witness, that would be prudent, whoever the witness is.
Very
Thank
well.
you.
Victims counsel, I see you nodding. I just want to give everybody the floor, and good. Then we go to the next week, and that's a follow-up on this defense counsel. We would then like to inquire with you and the registry, but I already understood from the observations made by the registry that the testimony of witnesses could be scheduled in the week of the 28th of March. And my question to you would be if you could come back after the break with also a proposal for 2 witnesses in that week. Yeah. I look at the registry. Do you wish to make any observation on this point?
No, thank you, Your Honor.
No. Okay. Thank you. Very well. On the week of the 28th, is there any observation to be made by Mr. Prosecutor?
Observations, Your Honor.
Okay. And by the Victims' Counsel?
No, thank you.
It's clear from your side that you are ready to start whenever it's possible. Good. Yes, Defense Counsel, I will give you in the break some extra time so that we don't have a normal break, but just a little bit more for you to get organized with the team and your client. The next topic on the agenda is the remaining outstanding material that the defense intends to disclose to the SPO and the Victims' Counsel to communicate to the panel. Defense Counsel, the panel notes your submission indicating that the defense might disclose some photographical material, statements, or documentary evidence at a later stage of the proceedings. And we wish to remind you that pursuant to Rule 104, paragraph 5 of the rules, it shall disclose to the SPO, Victims' Counsel, the statements, documents, and photographs which it intends to use as evidence at trial within a time limit set by the panel, and no later. have lost the connection with Mr. Mustafa, so we wait.
Your Honor, for my information, we sit also on Tuesday, Wednesday, and Thursdays in the weeks, in those weeks.
I have to wait. We have not, to be honest, we have not decided anything yet. I'm here really tentatively looking for the possibilities we are, and already gathered a lot of information which we will use for our deliberation. But as you might understand from what we are saying, we are looking at the week of the 21st and the 28th. We might need a few minutes, and I will get an update as soon as as it is possible, and then we can see if we have to adjourn or if we can continue. I will ask you later on if it would be possible to have two witnesses, one or two witnesses waiting to give their testimony. So I will repeat the question afterwards when the accused is present too, but for your information. I've received an update. The hearing will be adjourned for 15 minutes, so at 10:30 we will continue. Okay?
All right. All rise.
Please be seated. Defense Counsel, I see you're standing, but I also remember that there was halfway a question for you with regard to the outstanding material that the defense intends to disclose. So I can continue with that, unless you think it's very urgent that the point you have to share with us. Yeah, you can do it later on? Okay, thank you. Okay, I will, it's good that you are back. The connection is restored, Mr. Mustafa. I see that you are here again. I hope that the connection remains intact. We keep an eye on it. Let me see. Mr. Mustafa, did you hear that I addressed the topic regarding the outstanding material that the defense intends to disclose to the SPO and Victims' Counsel and to communicate to the panel?
No, Your Honor.
Then I will start from the beginning. Now, the next topic is the remaining outstanding material that the defense intends to disclose. And the panel, Defense Counsel, notes your submission indicating that the defense might disclose some further photographic material, statements, or documentary evidence at a later stage of the proceedings. And we wish to remind you that pursuant to Rule 104, Paragraph 5 of the rules, you shall disclose to the SPO and the Victims' Counsel the statements, the documents, and the photographs which you intend to use at evidence at trial within a time limit set by the panel and no later than 50 days prior to the opening of the defense case. So that is already very soon. And the panel further notes the SPO submission filing 338 indicating that the Rule 95 summary for the witness 500 was not notified pursuant to Rule 104, Paragraph 1. And it was not enclosed in the defense notice of alibi, and it was disclosed only on the 3rd of March. And this statement has been taken in March 2021. Defense Counsel, would you like to submit any observation on the point raised by the SPO?
Well, Your Honor, we remain with that witness, and even though this person also testifies something about the whereabouts of Mr. Mustafa, the primary issue is that this person, he is, as an LDK member, as a president of one of the branches of the LDK, in the best position to testify about the issues regarding whether there was any animosity within LDK regarding political affiliation or anything else, rather than the fact that he indeed also met Mr. Mustafa on several occasions. So that is actually the reason why he was not included in the first group of people, but that is the reason why we have included him in the second. And we do believe that this is a witness that we would like to hear, and I think it is important for the determination of the entire case, useful that this person would appear.
Thank you, Defense Counsel. Mr. Prosecutor, would you like to raise anything in this regard?
No, we included our position in our submission in this regard. So this witness should have been notified with a notice of alibi. Maybe there are other reasons why this witness has been notified so late. Maybe the defense counsel could elaborate further on that. But this is the only thing I could say on that issue.
Okay.
Thank you.
Very well. Victims' counsel, would you like to make any observation on this point?
No, thank you. Nothing that would go further than what the SPO already stated. Thank you.
I have a look at the persons in the courtroom, and I see that for the SPO we are in the same composition.
We are.
Yeah, the Victims' Counsel also. I see you nodding. The registry too, and for the defense, I see that we have one person missing.
He will appear just in a minute. He's just upstairs to pick up a document for the registry.
Okay.
So Mr. Fatmir Pillai is not here, but he'll be coming soon.
Okay. Very well.
And may I, if we have finished that point, come back to the issue of the scheduling.
Let me see. No, please go ahead.
So, Your Honor, the issue is actually the 23rd and the 24th of March. And the first witness that would be possible to appear is witness 2 on our list. It's the one with number 200 indicated. And I think honestly that it would be useful to use those 2 dates for it. And we have completed his testimony, and then in the next week we schedule the other witnesses, because I do believe that we will, with that witness, he was also heard by the prosecution at one particular stage, we might need a little bit longer time than that. And if we are going to move up a person, and we try to squeeze that person into a morning session, I think that we will have, it would be better to use a full day for that particular witness, witness 200 I'm speaking about.
Okay, but that you are talking now about the 23rd of March.
That's right, so the
Yes.
23rd and the 24th morning session.
Yeah.
As
If
I think that
if that is possible,
yeah.
that I note that,
Yes.
and that would be a
So
way
that-
to proceed.
And it would kind of conclude properly that particular witness without need to putting him into two sessions. So I think that if we have all the documentation, then we can just move on with that witness in the first week. And then in the second week, that is the week of the 28th. And my question, Your Honor, was how many days in a week do we sit?
We
In-
will
in-
have to decide on that.
Okay.
But for us, and then I mean the panel,
Yes.
yeah, it would be helpful if you would give us 2 names, huh?
Yes.
And then we have to further deliberate on
Yes.
how and what and
Yes.
how we are going to proceed. So
Yes.
I cannot be too clear yet, because we are
Okay.
in
No.
a deliberation process and in a moment of gathering information.
Yes. So what we come up with is on 23 and 24th to do witness 200. That is number 2 on the list.
Oh.
And then
Defense counsel, sorry to
Yes.
interrupt you. I have been informed that the first witness,
yes,
so number 1 on your list,
yes,
could be heard in the week of the 28th. That apparently
Yeah.
the papers would
Yeah.
be ready.
that was just what I was
Okay.
going to speak about, because we
Yes.
consulted with each other in the break.
Very well.
And then most probably, Your Honor, in the same week, we would probably be able to simply proceed with a witness 3 on the list.
So 2, 1, 3.
That's right, yeah. And then we do not get mixed up in orders or dates or whatever. We are more or less in a chronology as well.
Very well. Very well.
That's
No, that is good that that point has been discussed. No further observations from the side of the prosecution?
No observations.
Thank you. Victims' Counsel?
Just for clarity, in terms of timing, the 7 hours estimate by the defense obviously don't include any questions either from the SPO or from us. So it would, I guess, be 2 days a week for one witness who's scheduled for 7 hours. Is it just to be clear on the scope of time that we will be spending?
That is still something that needs to be discussed, so I cannot answer you on that. We have received a request from and an estimation from the defense, and we will see how to approach that issue.
Okay, thank you.
Yes. To the registry, do you have any observations on this specific matter?
Thank you, Your Honor. Just to confirm that the schedule just set out by the defense counsels, this can be accommodated by the registry.
Thank you very much. I have a follow-up, or I have a question that I already put to you, but then the connection, we lost the connection with Mr. Mustafa. My question is if the registry could accommodate one or two witnesses. So you already confirmed one, but could accommodate two witnesses to be in line in order to have always somebody ready for the next testimony.
Thank you, Your Honor. Yes, logistically, from the registry point of view, it's possible. We always try to limit the time the witness spends in The Hague. But that aside, if the testimonies are very short, of course, it makes perfect sense, and it is possible to do.
Okay, thank you for that to the registry. Yes, Defense Counsel, we have now been discussing the 23rd and the 24th in the morning. Could you already confirm that the 22nd you could be doing the opening statements?
Yes, I can.
Okay, thank you. Thank you for that. Yes. Now, next point on the agenda, or next point I would like to discuss with you is the indication by the defense that the witness for the defense, 100, so the first one, will testify as an expert witness. That's Annex 1 of filing 333. And the panel notes the submission that witness for the defense 100 has been indicated as an expert witness without proper notification of the nature of the witness evidence and without following the procedure set out by Rule 149 of the rules. Defense Counsel, would you like to submit any observation on the SPO submission on this point?
Yes, Your Honor. We this gentleman, this witness, is a person who was in the general command of the KLA. So that is the basic ID of this witness. Apart from that, he has particular expertise. We do not intend to use him as an expert witness in the sense that he is an expert on a particular material issue. However, he has expertise regarding that. But once again, this person is a person who was a member of the general command of the KLA, and therefore obviously can give clear lines about how orders went, what was the proper line of command, and so on. That is basically what we want to use this witness for.
Okay.
So
But he is also a witness.
He's a witness in the
witness
sense
in the
of
sense,
inter-
and the word
yeah.
expert
Yeah.
was an addition from your side to
That's right.
point out
Yeah.
that in your view he has specific knowledge on a specific point,
Yes.
but you were not referring to the rules of procedure and evidence in the
Exactly.
more formal point,
Yeah.
in the more formal approach.
No.
Okay. Mr. Prosecutor, would you like to raise anything in this regard?
We are absolutely fine with this explanation.
Okay.
Thank you.
Thank you. Victims' Counsel, would you like to make an observation?
On the point of the expert witness status, no. Thank you.
Thank you. Very well. Then we have this, yeah, the panel takes note of the Victims' Counsel submission filing 297 and filing 334, requesting the panel to appoint an expert on medical forensic evidence for the purposes of individual reparations and truth finding, as well as to authorize one participating victim, victim 0505, to directly address the panel to present views and concerns. And although I think I know the answer, but the panel would like to know first whether victim 0505 would be ready to address the panel on Monday, 21st of March, 2021, if authorized. We still have to take a decision on that. And on this, the panel notes the registry submissions indicating that the appearance of victim 0505 can be facilitated at the earliest on the 21st of March 2022. And second, Victims' Counsel, you have already made an opening statement at the start of the trial on the 15th of September, and you have requested the panel the equivalent of 2 sessions for your presentation. That was filing 283. And the question of the panel is, does this encompass the presentation of the views and concerns of victim 0505? And does the Victims' Counsel intend to make further oral submissions to the panel before or after the presentation of those views and concerns? And with regard to the victim who will be expressing the views and concerns, we would like to stress in this regard that the person should not repeat what he has already said or she has already said in the statement to the SPO, which has already been admitted into evidence under Rule 153 of the rules. Rather, the victim should focus on and convey the views and concerns going beyond the evidence previously provided. Yeah. And third, the panel would like to inquire with Victims' Counsel whether she intends to request the appointment of an expert in addition to the one she has requested for the medical forensic examination of some of the victims. That's filing inter alia 297, for the specific purpose of assisting the panel in the determination of the compensation to be awarded to victims for the harm allegedly suffered, should reparations be ordered in case of a conviction. So if the panel would enter a conviction and we would enter into the determination of compensation to be awarded to victims, is the Victim Counsel requesting the appointment of an expert on the financial compensation? And otherwise, how does Victim Counsel foresee to proceed in this regard? You have the floor, Victims Counsel.
With regard to the views and concerns to be represented by victim 0505, we will be very careful, if authorized, that we will not hear any repetitive statements, but rather complementary to what the evidence so far has shown. If we make any further oral observations from my part. They will be very short, so that overall, and this is subject to one further meeting that has to be had, it will not take longer than one morning, possibly even just 1.5, 2 hours as initially indicated. It is a rather short presentation, presentation and in combination with the observations by the victim. With regard to the appointment of the expert, it would be great if we could have a few minutes just to liaise between co-counsel and me to further discuss that. Is that all right?
I propose that we use the break for that. If you can liaise now, feel free, but you might want to pay attention to what's happening here too, so we don't have to overlap. And I think we are not in a rush today. So yes, thank you for that.
Your Honor, may I for a brief second?
On this, because I would first, shall I first finish this point and then
Sure.
you get the floor on the topic you would like to raise. And let me see. Defense Counsel, would you like to raise anything in regard to what was just said by the Victims' Counsel?
No, Your Honor, we have no observation.
And does the SBO wants to make an observation on this point?
No, Your Honor, we will wait for the final position of the Victims' Counsel on the second issue. With regard to the first issue of the victim 0505, no further observations.
Okay, good. And the registry, is there anything you would like to say on this matter?
Thank you, Your Honor. Nothing from the registry on this.
Thank you. Defense Counsel, I saw you standing. You have the floor.
Just the previous topic that you discussed was the outstanding material,
Okay.
and you gave the timeline. I just wanted to say once again, we do not foresee anything in particular. If it should be, it would be a document, a photograph or something, but there's not going to be
A lot, but
no. Just
but-
it is just sometimes something comes up, then at that time we will file accordingly according to the rules that you just set out. But we do not foresee anything in this right.
okay. I note that Mr. Fatmir Palai came in, and I realized that was already 10 minutes ago, but I acknowledge your presence again in the courtroom, and for the record, you have been here for more than 10 minutes now. Good. Yes, there is another topic I would like to discuss with regarding the defense list of exhibits and legal workflow. Defense Counsel, we have noticed in your list of exhibits, and that's filing 333/core/AO2, as well as in legal workflow, that there are several, how would I call them, irregularities, and we need to address that because, the way we refer, or the exactness of the way we refer to ERN numbers must be 100% trustworthy. And also the SPO has raised a number of issues in this regard in its written submissions. And it's a list of several points. Now, we note that the ERN of multiple items on the defense list, as they appear both in the list and in legal workflow, do not correspond with the ERNs stamped on the items themselves. And by way of example, item 18 on the defense list appears both in the list and in legal workflow with the ERN DSM 00198 till 00198, but it is stamped with the ERN DSM 00199. Other items appear correctly in the list, but still have an incorrect ERN in legal workflow. And this is the case with the statement of, for example, witness 500, which is stamped with the ERN DSM 00570 till 00578, but appears in legal workflow under the ERN DSM 00579 till 00579. Second, and as a consequence, different items have been registered in legal workflow under the same ERN. So, for instance, ERN DSM 00561 till 561, so it's the same page, identifies in legal workflow both the statement of witness 200 and a copy of his ID card. And the panel reminds the defense that each item should have a unique ERN. And third, at times, one and the same item has been disclosed twice. So either under the same ERN or under different ERNs. So, for instance, one and the same map has been disclosed both as DSM 00421 and as DSM 00447. And this is true for several annexes to witness statements which have been disclosed both as part of the statements and as separate items, as in the case of witness 1400. And lastly, the panel notes, as pointed out by the SPO, that information on the provenance of certain items is missing in legal workflow. And we note that these are not isolated occurrences, but there are, yes, I must say, numerous items on the defense list of exhibits with these problems. The panel wants to express its concern in this regard, and we would like to hear whether the defense has faced any difficulties and what has happened, because we should have a system that should be as perfect as possible, because when we refer to the different ERN numbers, it's going to get very complicated if the numbers are not correct. It's just a library you have with no efficient access to the books in it. We cannot work in that way. So we have to resolve it. But I would like to give you the floor to see if what your reaction is on this. You have the floor, Mr. Defense Counsel.
Well, first of all, Your Honor, the disclosures have been done 2 times in total. And that was in order to ensure that the Victims' Counsel was also getting everything that was needed. Now, to the best of my and Mr. Pelai's knowledge, we have done a correction in the filing. Now, I cannot tell you which ones. He would know. He would be in the best position to tell me about it. But, huh? Yeah. In any event, corrections will be made, obviously. We'll just go once again through the entire list, yes, and then see whether the document which is stamped has the same ERN number as on this list. Now,
and
yes.
also that is an important point, and
Yes.
thank you for doing that.
Yeah.
It's very important.
Yeah.
But also that each disclosed item
Yeah.
has only one ERN number.
Number,
Because
yes.
what has also happened is that you have a statement
Yes.
with the attachments you have shown to the witness,
Yes.
and then we have another batch with a disclosure
Yes.
with all the items again,
Yes.
which have received, in that case, another ERN number.
Yes.
So the same, the attachment attached to the statement has that ERN number,
Yes.
and then it has an individual ERN number.
Yes.
And there will come a moment in time that will raise confusion when citing documents.
And what I understand is that you would like to have one single ERN number, obviously.
Yes, of
B-
course.
Because I remember how it was filed back in at the end of April, I recall, that at that time all the attachments were included in the statement, which we found would make it more easily readable for the reader. Apart from that, to give each of such item a separate ERN number. So that is why I think 2 ERN numbers might appear. Now, I have to consult with Mr. Palai about it, but what would be the preference? Because we could either list the 2 ERN numbers under which a specific photograph is listed, once as a separate item and one as the attachment to a statement, or just have each and every one as a single one. I'm not sure about what is the easiest way to go about.
You has confirmed what I was going to propose to you, that 2 things. You can discuss with CMU further details, that's one thing, but on your specific question, I would say, and it was confirmed, that once a document has an ERN, yeah, we don't change it anymore. Because if not, it gets confusing. But what is also very important, that but you already indicated your willingness to go through all the items on the exhibit list and to have the same numbering on the document as in legal workflow. Also for, it's evident for reasons of reference. Let me see. Yes.
Well, we will obviously, if corrections are made, probably file a new second corrected version or third corrected version, or
That was my next question, and we will for sure give an oral order on that. But thank you for expressing your willingness on this. We would then like to have kind of a final list, which will be the reference point of parties, Victims' Counsel, and the panel when referring to the exhibits of the defense. So, very well. Yes, and there is this point that the origin, the provenance of certain items is missing in legal workflow. That should be added to. Mr. Prosecutor, would you like to raise anything in this regard?
No, Your Honor, thank you. Nothing further. We had noticed these issues and we had liaised with the defense, in particular for the originator, which is very important on the side of the other corrections. But you covered everything. Thank you.
Thank you. Victims' Counsel, would you like to make any observation?
No, thank you.
Very well. It's now 5 minutes past 11. We will adjourn now for, we will break now for half an hour till 11:35, and the hearing is adjourned.
All right.
rise.
Please be seated. Okay, I will call appearances, and I see that we are in the same position as before the break. Yeah, and I see everybody nodding, so we can take that as a yes. Very well. I will go now to the point of the protective measures for the victim wishing to present the views and concerns. But before I do that, Victims' Counsel, did you confirm that the victim could present views and concerns on the 21st of March? Because I realized afterwards that I didn't hear that.
Your Honor, yes, apologies. I actually, this slipped my mind. As long as the registry, as they have confirmed in their submission, is able to do their part of the facilitation, the 21st of March is fine. So I can confirm that. And if you would like, I can also address the other outstanding question on experts, but we can also do that at a later stage.
We will be talking about the protective measures, and you can start with that, and then we will go into the protective measures. I mean, it's...
Okay, good, because then just to finish up on what was left open from before the break, just to be clear, and perhaps, and I apologize if that was the case, our two submissions were maybe slightly confusing there to some extent. Just to be clear, we do not request 2 expert examinations. Just to be clear on that. The proposed examination is, in our view, clearly relevant for questions of compensation, as you've said today, or in the past we more broadly refer to reparations. And this is our primary request, based on Rule 168. Yeah? And this expert then to be appointed by the panel. But only if the trial panel deems it necessary to support its truth-finding efforts. And this is something that we cannot fully determine. We, from our perspective, think the prosecutor has laid out a very solid case that doesn't require any further expert examination to support, for example, witness credibility. But at the same time, ultimately, it is the trial panel who will have to decide on this. So if in the efforts of the trial panel or in its mission to find the truth, you deem it necessary, at your discretion, that such an examination may be of further help to you, then, and this is really just a matter of timing within the procedure, such an examination may be done slightly earlier than only at the reparations order stage, and done as envisaged in Rule 132/127 at the end of the defense case. Once you know what your preliminary assessment is, because we are driven by trying to use an approach that is as sensitive as possible to issues of re-traumatization, for example, and of course every examination is rather stressful, and this is why we have these, this stepped approach, or this phased approach, if that makes sense. And I hope that this is now a bit clearer.
Okay. Thank you, Victims' Counsel. I think there is a slight misunderstanding, and I will try to clarify. What you just explained to us was clear to us. You have made your 2 filings, and it was not ambiguous for us what you were requesting, and the purposes of both reparation and the truth-finding component. And you have explicitly said that, in your view, what was presented was enough, but of course you can always corroborate. That's how I understood in my words, with extra information. That's one thing. The question from the panel is an additional one, and that is if the Victim Council's team is considering to request the appointment of an expert in addition to this medical forensic examination that should assist the panel in the determination of an eventual, if we would enter a conviction, in the determination of the compensation to be awarded. So that's much more a numeric exercise. And I just want to put it on the table, and I would say no need at this point to react on it now, because we can imagine that it needs some further thoughts. And if it's not an expert, if you are foreseeing to proceed in another way, or we are not doing your case here, but for us it's important to already envisage what is coming in possible further phases, like we have been doing all the time. That's the point the panel wanted to make, and if I was not clear before, I hope I have clarified it now.
Thank you very much for that clarification. It's well noted. Thank you.
Okay. Good. Then, very well. Does the defense want to make an observation on this point?
No, Your Honor.
Okay, very well. With regard to the protective measures, the panel recalls that victim 0505 has been granted anonymity under Rule 80, paragraph 4A under E of the rules, and the name and identifying information shall be withheld from the public and the parties. Victims' Counsel, would you like to submit any observation on this point?
Given that protective measures are in place already, we think that their scope is possibly sufficient. I will be further guided by the experts of the WIPSO experts, but that with those protective measures continuously in place, the appearance should be no problem.
Okay. Mr. Prosecutor, would you like to make an observation in this regard?
Yes, but on the previous point, I was not given the floor, and I didn't want to jump up on the issue of the medical expert.
Medical experts, I didn't give you the floor because we were talking about compensation, but if you want the floor, I can give you the floor.
If possible, very, very briefly. As indicated by the Victims' Counsel, and we fully agree that the prosecution case stands quite solidly on its feet, and we don't need such a medical expert for the purpose of any further assessment of evidence. With regard to the reparations, if there is a need for such an expert to determine the reparations, if granted, if there is a case that we have a conviction, then the prosecution will make necessary representations later on in this case, possibly after the conclusion of the defense case.
We will come back on this point, not now, but okay. Thank you for your observations. Very well. And do you have any observations with regard to the protective measures?
No, Your Honor.
Thank you. Defense counsel, no. I see you saying no. Yes. Then we have point 10, submissions on the eventual sentencing of the accused in the event that the accused is found guilty. More specifically, whether the sentence should be pronounced with the trial judgment or in accordance with rules 162 and 164 of the rules. We have read your observations. Thank you for that. Mr. Prosecutor, would you like to submit any further observation on this point?
No, we have submitted everything in the written submission, Your Honors.
Thank you. Just to make sure. Victims' counsel.
Nothing more from our side, Your Honor. Thank you.
And the defense counsel.
And nothing more from our side as well, Your Honor.
Thank you. That was the last item on the agenda the panel had foreseen for today. Do the parties and the Victims' Council have any other issue that they would like to discuss? I start with Mr. Prosecutor.
Nothing further, Your Honors.
Okay, thank you. Victims' Council?
No, thank you.
Thank you. Defense Counsel?
Yes, Your Honor, we will confer once again with CMU regarding this list of things. I just want to make one clarification why I think sometimes we have doubles. The idea was the following. We had a statement with a bunch of attachments, and sometimes we used the same attachment for the same witness or even for another witness. It could be a photograph or a map that was initially made. And later on we also made specific maps after we made some measurements. All those items we thought it was useful to also do that separately so that any party could ever use such a photograph or a map or whatever it was in it. That, I believe, is the reason why sometimes we have this kind of doubling, even though it is the same document. So, for example, if it is an aerial photograph, so to speak, that we show to witness A, maybe the same photograph was shown to witness B, and so on. They got separate ERN numbers, even though it is the same photograph. That is, I think, the reason why. We'll go through it once again, and for us it made a kind of a logic to read the statement together with that attachment. That was the idea, and that is how it was done initially. We have refiled it. We taken a clear note of the issues, but that is just to explain to you why that would appear on multiple ERN numbers sometimes, even though it is the same document. Okay, that's all I wanted to say. But we will confer with CMU again on it and see. But what we will not do is divert from the stamp which is on the document, but reuse that same number probably in any other item that follows.
Okay, I would say on that specific point, please liaise with CMU.
Yes.
Because if it becomes very technical, I don't want to say something to you that in the end we have to.
Yeah.
But the number should be the same in legal workflow as on the document,
Right.
because if not, we cannot retrieve the document. That
Yes.
that is
It
the
is simple
problem.
as that.
Yeah.
Okay, that is all I had to say, and that's why I wanted to clarify that once again. We'll
Okay.
get to it, and there'll
Okay.
come then a new corrected version. It's a monk work, but it's we're going to do it. We take care of it.
I know it's a monk work, but this monk work has to be
It
done.
has to be done.
Has
No
to be done,
problem.
and it's done by everybody. So.
Yes, absolutely.
Very well. Then we have arrived at the end of our conference for today. The hearing is adjourned till tomorrow 2:30, and then the panel will issue a number of oral orders. I thank the parties and the Victims' Council for their attendance, and I thank the interpreters and the stenographer and the people of the audiovisual booth, security, and last but surely not least, the registry for their attendance. The hearing is adjourned.
All rise.